I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. Probably the most common lessee default involves the lessee's business actually failing. In modern parlance, that means the lessee is going into a Chapter 11 reorganization or has actually filed for bankruptcy and is about to go completely out of business. Most Chapter 11s do result in the lessee's business being liquidated. From the equipment leasing perspective, a few comments. 1. You are better off with a true lease if the lessee goes bankrupt, whether it's a reorganization or an out-and-out bankruptcy. In the reorganization, the lessee has to affirm or reject the lease. It is an executory contract. That may give you the opportunity to require the lessee to completely cure the defaults and get your equipment back as an alternative. Second, if you think your lessee is going to be filing for Chapter 11 protection, by all means declare the default at the earliest possible opportunity and get that equipment back. If your lease has been declared in default and terminated prior to the lessee's bankruptcy filing, the equipment should not be considered part of the bankruptcy estate, which means you may be able to get that equipment out of the bankruptcy a lot faster. Second, by all means, don't just rely on the so-called ipso facto clause. It's a common knowledge among lessors counsel that those clauses are actually not enforceable as written. The bankruptcy laws supersede them. So, if you have any reason to believe you're working with a weak credit lessee, consider putting financial covenants into your lease or taking other actions that will let you move before the lessee actually goes out of business. Closing the lessee's business, material change in business, change in management, material adverse change, if you can get it, in the business or financial condition of the lessee. Any of these are things that you might not normally want to deal with, but might give you a valuable second look at the financing. Always bear in mind, moving quickly is important before you get into bankruptcy, but once that bankruptcy petition has been filed, whether it's a Chapter 11 reorganization or a Chapter 7 bankruptcy, you cannot take action adverse to the lessee. No taking the equipment, no calling a default. For this and other information, visit us at www.leaselawyer.com.